Welcome everyone to the 2022 Highlights and Recap webinar. Thank you all so much for joining us. Our moderator for today's call is Beth Allen. She'll be answering the questions you send through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We'll be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday you will receive an email with a link to the full recording. At this time, I'd like to hand over the call to our speaker. Beth, the floor is yours.
Good afternoon for everybody except, even on the West Coast, it's afternoon. So good afternoon, everybody, and welcome to the 2022 Get Wise Wednesdays Live. If this is your first time with us on one of these end of the year presentations, then you might be surprised to see all of our faces because normally January through November, we do not do this. You just have slides up in front of you. And today we thought it would be better to have you see us looking our festive best and saying, have a great end of the year. So today we're going to just be talking to you. So you actually have to listen to us and kind of pay attention to what we're saying. But we did provide slides because we know how many of you love your slides from us, okay? And so if you look in the chat, I did include a web link to the slides that kind of encompass the information that we're going to be talking about today. And you'll want to follow those if you just have to have slides, right? But we're hoping that you'll talk with us, have a chat, okay? And as always, go ahead and enter those questions into the Q&A. Myself and the team will be working on those, and so we should still be able to answer those. But just take it easy on us, guys. It's December, okay? All right, so we're going to jump into today, and I am going to kind of be moderating. Now, interestingly, we always give you a disclaimer where we come on and we say, look, a lot of us are lawyers, but we're not your lawyer. This is also not tax advice because none of us are accountants. So please understand that what we provide today is just informational guidance that we are giving you. And I also have to point out that all of what we're saying today is good as of today, right? And that's usually not, usually it's good for at least a few weeks. But I'm literally saying that because depending on what happens with the rest of the year, there could be elements of it that change tomorrow. Okay. So keep that in mind, but we'll talk a little bit more about that in a minute. And then the team that you're looking at, it's always interesting on Zoom because I never know what order we're in for you on the boxes, right? I think it's in order of who logged in first. But it's myself, it's Chase Cannon, wave or something, guys. Carol is joining us just a little bit later on, but she will be here. Patrick Myers, Sarah Burns, Yoko Yoon, and Kelly Ekman. And I think that you all are pretty much used to all of us. And now you see a black dot square for this guy named Roger Abramson. And he is the newest member of the benefits compliance team. He just recently started with us. Welcome, Roger. We were nice enough not to put him through the ringer and make him talk today because he's only a couple weeks in. So we're going to try and be polite. But Roger is the newest guy on the team. So welcome to him. And I'm sure you will hear from him in Get Wise Wednesdays to come. All right. So let's jump into the information. Today, we're going to go over a number of things. I'm going to talk a little bit about election results and kind of what those mean for benefits compliance. We'll talk about COVID because that's still technically a thing, right? But Chase will kind of give you an idea of what is the most important on that now. Patrick is going to talk about the family glitch. Sarah is going to talk about MAPIA or mental health parity. Yoko is going to talk about state law, and bless her because she actually likes all the state stuff and has been doing a phenomenal job on it. I'll talk about a little bit of retirement. Carol, once she makes it, will talk about surprise billing and transparency requirements. And then Kelly will end us out with a couple of other health and welfare compliance issues that really just didn't fit neatly into any of these other subjects, okay? So that's where we're going. So I will start off by talking about just the election results. We all watched kind of what happened. If you were kind of looking for it to be exciting, it was kind of maybe a big nothing burger. And I say that because I think going into it, everybody expected that the House would switch to Republicans and that the Senate would stay potentially in the Democrats' field. But we all knew that the presidency, no matter what, was going to be a Democratic administration on the presidency. So no matter what, we were going to be looking at split government. And that's what we're looking at today. And so, interestingly, I think from the health and welfare benefits standpoint, one thing that I will bring up for this election is this was actually the first election, if you paid attention, to where no one actually campaigned on repealing or replacing Obamacare, right? So that is firmly behind us. that hopefully is no longer a thing, right? We're kind of just going forward with that. And now it's kind of an issue of how we're going to make hopefully that better. And Patrick will be the first one to talk. Actually, not Patrick. Chase is going to talk. But after Chase, Patrick will talk about one of the issues that came out of the Affordable Care Act. That was really kind of the only thing that you're really going to be, is a really big change, I think. And so really, as far as what happens next with that, a whole lot of nothing for like 2 years at least, right? And I say nothing, there's always some stuff, right? But nothing that is very, intricate. Obviously, we're not going to wake up tomorrow and there's Medicare for all, right? Nothing that's extreme is going to happen because frankly, only issues that really have really wide bipartisan support are going to get through at this point, right? And so that is not going to be the super, let's say, extreme things that, we might expect. That's really going to be things that everyone agrees on. And so we're going to talk about a few of those today. So like some of the things that everybody agrees on are the Secure Act and retirement, MAPIA, so mental health parity, everybody kind of agrees. I think there's some differences in what, how they would make it happen, but everyone somewhat agrees. And then transparency and coverage, that's already kind of started, but there's some agreement as to whether or not, maybe there's some relief on the horizon on that, but we're going to see that kind of go on full force, okay? And so really, like I said, don't expect to see anything that's big and life-changing. It's really just kind of a situation where, for the most part, for employers, it's going to be business as usual with offering retirement even and health and welfare plans, right? So you're still going to have to comply with all those requirements that we have year in and year out, and there's not going to be anything huge. Where we might see some action is, first of all, I mentioned on the start of the call that all of this information is good today. Because what we know we will get from the government is an end of the year reconciliation bill. That is basically the budget. And we know that because they can't really agree on anything right now. We're in the last, 16 days of having a government that's controlled by the same party at all levels. And so we will see, I assume, some of those things that everybody agrees on in the reconciliation bill. So we'll talk a little bit about some of those today and see if potentially we'll see that in the next few days, right? I think they're going to shut the government down by the 16th or the 18th. I think Roger told me, I think it's like the 16th. So we do expect to see some kind of bill that comes out and pays for the government, and it could have a number of benefits related things in there. But otherwise, all you can really expect is that the Biden administration is going to try and pass certain legislation. Or not legislation, regulations. So they're going to try and come in as the executive branch and potentially, make some regulations that address, what they think should occur on certain issues. But even with that, we've seen a lot of litigation against kind of anything that at this point any president does from a regulatory standpoint. Okay. As always, when something changes, we will tell you, right? So you will know that it is changing and you need to pay attention because we're going to mention it. All right. But that's kind of the major takeaways from the election results. And now I'm going to turn it over to Chase to talk about COVID and kind of where we are with that.
Thanks, Beth. And thanks, everybody, for joining. And it's the legislative section, even though Beth just said, I'm looking at your name on the screen, and it's Elizabeth. I'm like, no, it's just Beth. If she described this as a nothing burger, but we, then proceeded to talk about a lot of things. So, but if that was a nothing burger, the COVID and pandemic type of regulation and compliance that came out of it was an everything burger, right? It was suddenly like all of a sudden, so much came out during the pandemic. And so the question is, what is ongoing and what is sort of wrapped up now that we are at least starting to move forward out of the pandemic a little bit? And so we're going to talk about the biggest thing, which is the extension of timeframes here in a sec. But just like high level, we kind of broke this in the slides that you'll see eventually into kind of 6 buckets of items. And the first is no cost COVID-19 tests and vaccines. In other words, you can go get your test or your vaccine without cost sharing. And that one is still ongoing. We're going to talk about that one in just a sec. The retirement plan relief is mostly over. That includes loans, hardship, partial plan termination, and physical presence and some waivers and relief. So most of the retirement stuff we're sort of past, and we don't always focus hard on retirement, but Most of that is passed. The FFCRA leave, if you remember that, is also over. And so that was just the idea of being able to take paid leave to be able to handle situations related to COVID. The extension of certain timeframes we're going to talk about is ongoing. That's the bigger one. The ARPA COBRA subsidies, if you remember that, where COBRA was going to be subsidized, that is over, and we don't have to worry about that anymore. And then there was some Section 125 relief. In Section 125 is sort of what allows pre-tax contributions, pre-tax deductions for elections, for medical plans, for dependent care, and for health FSAs. That's basically over. If that was allowed during the pandemic, then plan documents might need to have been updated. And so that's one area where we still see employers might need some help. But that really leaves sort of the no-cost tests and vaccines and the extension of certain timeframes is what is still on the calendar in 2023 and has been the primary thing out of the pandemic-related items that employers had to deal with in 2022. And so talking specifically about the rules for extensions of certain timeframes, the idea here is that we have deadlines generally related to the plan and deadlines to enroll, deadlines to elect COBRA, deadlines for claims submissions. And what the rules originally said was basically, look, we're going to give you a little bit more time here because we understand everything is difficult in a pandemic environment. And so basically this put on pause many of these requirements or delayed them or pulled them is another way to say that. And so the deadlines were delayed until the earlier of what we call the outbreak period. And I always think of the movie Outbreak when I hear that. But the outbreak period is defined as the earlier of 1 year or 60 days after the declared end of the national emergency. And so we've just been kind of living with this outbreak period when it comes to plan administration, and it's been challenging, and it creates a definite wrinkle. But the deadlines we're talking about are the 30-day or the 60-day, if applicable, deadline to request a special enrollment under HIPAA. So for our HIPAA special enrollment rights, you have that extra time, which again is a year, or 60 days after the end of the declared national emergency. So HIPAA special enrollment, 60-day COBRA election period, the 30-day or 60-day if applicable deadline to notify the plan of a COBRA qualifying event, and then the deadline for plan administrators to furnish COBRA election notices and premium payments relating to the 45-day deadline for first COBRA premium, and then 30-day deadlines for subsequent. So COBRA premium payment delays. It also applies to claims for benefits. Generally, those are governed by certain timeframes, and those are basically just giving people more time to be able to submit claims and appeal things. And then that also applies to deadlines for providing state or federal external review, which is part of the appeals process as well. And so this creates a challenge. And I just want to go through one example, and then we're going to talk about the different proclamations, this outbreak period that's related to the national emergency versus a different proclamation, and that's been confusing. But first, just as an example, if you have an employee that missed enrolling their newborn in coverage within 31 days of the child's birth, the question we often get is, can we extend that enrollment window for that HIPAA special enrollment? That would obviously be a HIPAA special enrollment event. And the general answer is yes, that original window is kind of a baseline that you have to have it open for. But what happens now is with this extension of certain timeframes, while that normal deadline that has to be extended until the earlier of 1 year or 60 days following again this declared end of the COVID-19 national emergency, which we call the outbreak period. And so the plan in this situation would be required to extend that enrollment deadline for employees who experience those HIPAA special enrollment events. Remember that those don't apply to standalone dental or vision benefits. That's just a little helpful tip, and that's because those benefits generally are not subject to HIPAA. And so, again, this is not taking what was there before and making HIPAA special enrollment applicable to all types of plans. It's just saying for those plans where a HIPAA special enrollment right would apply, now you get this extended window. So that's just one example. COBRA is the other example. Being able to enroll in COBRA up to a year and 60 days later is an option. We just have not seen it happen a lot because you would be required to pay COBRA related premiums. And so that's not something we've seen as a major issue, but it is out there as something that the plan has to follow. And if it comes up, it is something they would have to follow. So before I pass it over, I just want to talk about these two proclamations that have caused a lot of confusion. And again, this is in our slides, but there are basically two kind of proclamations that are in play here, and they relate directly to the two items that we said are still ongoing here. So the first is what we just talked about, the extension of certain timeframes, this outbreak period. That is tied to the President of the United States, who is currently President Biden. The President of the United States proclamation, that is impacting how long this extension of certain timeframes, this outbreak period. And currently that is extended through February 28th of next year. So the president could end it earlier. It could also go longer. And but that is that's the national emergency we're talking about in that context. Now, the other proclamation that you may hear about and has caused confusion is the Department of Health and Human Services proclamation. And that one is something that is related to the coverage of tests, COVID tests and COVID vaccines, having to cover that without cost sharing. That proclamation is one that has to be renewed every 90 days. And so this one continuously has come up. I think this is the 11th renewal of that since it started back in 2020. And the current one it ends on January 11th of 2023, but the rules, or at least the government has said, we will give you 60 days advance notice before we stop that, which makes us believe that they are going to extend that for another 90 days, meaning we will be into April of 2023 with that proclamation still in place. So I just wanted to mention that. You'll see it in our slides, but it has caused confusion. We wish they were tied together directly. We wish there was simplicity on a lot of these rules, but that's what we're here for, is to walk you through that and make sure you understand. So those are the two main things that we're going to be monitoring and that you'll have to pay attention to in 2023 with respect to coming out of the pandemic here.
I think it'll be a group goal to not have to do any webinars on COVID next year, but who knows, right? People are actually still getting COVID, so it's hard to tell. But thank you for that recap, Chase. So now we're going to move on to Patrick today. And I should have said on the onset, it might seem like we're jumping around a little bit, but just because this is like a review of the whole year and it was a bunch of random stuff. So Patrick, do you want to talk about the family glitch and what's going to happen with that?
I sure will. Thanks, Beth. First of all, when we're talking about the family glitch, we're not talking about the thing that happens when your holiday dinner goes horribly wrong. We're actually talking about a phenomenon or a hole or a gap in coverage in the ACA. Recall that under the ACA, large employers have to offer affordable coverage to their employees. And affordability is usually determined by determining whether or not an individual employee's self-only coverage is affordable, which is no more than 9.5% of their income, which is indexed annually. I think this year it's 9.6%, and next year it's 9.12%. But that's how it was normally determined. And unfortunately, what that meant was that family members who would be were previously ineligible for a premium tax credit if it was determined that an employee's self-only coverage was affordable, but of course, self-only coverage doesn't cover family members. So family members would have to go get other coverage, but unlike an individual employee whose coverage was unaffordable, family members could not go out and get a premium tax credit to help them pay for that coverage. But this year, the IRS has promulgated a new rule so that effective the beginning of the year on January 1st, 2023, there is going to be a separate premium tax credit affordability standard that allows family members to get that premium tax credit under certain circumstances. Essentially, an eligible employer-sponsored plan will be treated as affordable for family members if the portion of the annual premium the employee must pay for that family coverage doesn't exceed that what next year will be 9.12% of their annual household income. So that means that if that portion of the coverage does not exceeds that amount, then family members can go out and get that coverage in the marketplace and may qualify for a premium tax credit as a result. And so there may be cases now where an employee's family can qualify for that premium tax credit even if the individual employee, doesn't. A couple things to remember though when we're talking about this fix for the family glitch is that it doesn't impact the employee affordability test and does not increase exposure to employer shared responsibility penalties. So in other words, if a family member goes out and gets the premium tax credit, that's not going to necessarily trigger any sort of penalty based on that premium tax credit. Applicable large employers will continue to base affordability tests on the cost of self-only coverage, and employer mandate penalties will continue to be triggered only by an employee's receipt of a premium tax credit and not by a premium tax credit granted to their spouse or their dependents. Now, in addition to this fix, the IRS also introduced a new qualifying life event that allows participants to make prospective mid-year elections to take advantage of this fix. This mid-year election is limited in that it has to show that it can only allow an employee to revoke prospectively an election of family coverage under a group health plan that is not in a health FSA and that provides minimum essential coverage, provided both of the following conditions are satisfied. First, one or more related individuals are eligible for a special enrollment period to enroll in a qualified health plan through an exchange, or one or more already covered related individuals seeks to enroll in that qualified health plan during the exchange's open enrollment period. And two, the revocation of the election coverage under the group health plan corresponds to the intended enrollment of the related individual or related individuals in a qualified health plan through the exchange for new coverage that is going to be effective no later than the day immediately following the last day of the original coverage that is revoked. That's a lot of verbiage. It's in the slide, but it's important to recognize that there is a new mid-year election. It's available to both calendar year and non-calendar year plans. However, those conditions have to be satisfied in order for that mid-year election to actually be available to the individual who wishes to make that election. And that's it in a nutshell.
All right, Patrick. So if I follow you, it does not affect the employer's affordability, right? So their coverage is still affordable based on the single only coverage, right? It just means now that some of your employees might drop their family off of your plan. Is that correct?
Right. That's right.
All right. Thank you for that. Now, Sarah, we're going to have you talk about the Mental Health Parity and Addiction Equity Act, or for short, MAPIA, and what we got out of that this year.
Yeah, thanks, Beth. And I'll mention Patrick's background. He's actually the Home Alone house. I don't know if anyone noticed that. It's pretty great. Okay, so MAPIA, it's a big topic. And I guess if anyone out there needs some more information, check out a couple of Get Wise Wednesdays that we've done, one 2 months ago and then one last year. Lots of good information in there. But just to talk about it briefly, from I like to say 300,000 feet up, which is space. MAPIA requires group health plans and insurers that offer mental health benefits to cover those benefits in parity with medical surgical benefits. So in parity has different components. It has to do with cost sharing and treatment limitations. There's quantitative treatment limitations, which are coverage terms that are expressed numerically. So number of treatments, days of coverage. And then there's this difficult concept of non-quantitative treatment limitations. So coverage terms that can't be expressed numerically, like exclusions, prior authorizations, medical necessity coverage guidelines, that sort of thing. Parity doesn't mean that there can't be limitations in mental health coverage. It's just that the limitations on the mental health side, they can't be more restrictive than the limitations on the medical side, both in design, like how the plan is written, and then also in application, how claims are actually decided. So MAPIA was passed way back in 2008, but really compliance, knowing how to comply, and enforcement, it's been a challenge. We've had guidance from, we call the tri-agencies, the Department of Labor, Health and Human Services, and the Treasury. We've had guidance from them over the years, but it's difficult and sort of imprecise non-quantitative treatment limitation, or NQTL. So in 2020, we go back a little bit with the Consolidated Appropriations Act, there was a lot of things in there that affected group health plans. And one of those things was a new documentation requirement for NQTLs. This was the comparative analysis. So that's about identifying the mental health NQTL and then actually justifying its inclusion in the plan, meaning looking at how it compares to the medical surgical terms. And it's really a detailed, pretty complex analysis. And plans and insurers, they have to provide that comparative analysis when it's requested by a federal or state parity enforcement agency, or importantly, a plan participant. All right, so jumping into 2022, this past year, starting in January, there was a report to Congress from those tri-agencies on the comparative analysis, the reviews that they've done so far. And none of the analysis that they had from over 150 plans or insurers, none of them passed the test, none of them really hit the mark. Some of the NQTLs they looked at were immediately found to violate MAPIA, so like an ABA treatment exclusion for autism, but in most cases, they really needed more information. Basic problems identified, like the plans didn't start the comparative analysis until it was requested. There were documents that were provided without any explanation. Basically, there wasn't meaningful analysis in there. Another thing that happened in 2022, participant lawsuits, right? So these are brought under ERISA based on denied claims, and the case law under MAPIA has been slowly developing, like as courts have decided how and when these cases can be brought first, but then also like what is actually a MAPIA violation. Some courts actually have been digging in, and they're definitely going to continue. But in our October Get Wise Wednesday, we actually spotlit, I guess, a few of those cases. They often have to do with like medical necessity reviews, how claims on the mental health side are covered versus claims on the medical surgical side, and also some exclusions. Like a common exclusion that's being litigated is wilderness therapy, or again, autism treatment limitations. That's being litigated quite a bit. So if we look ahead to 2023 and think about like what's going to happen next, absolutely DOL enforcement, this is a priority, right? So MAPIA, like Secretary Walsh has essentially been screaming from the rooftops that it is a priority. So we know that the comparative analysis, those audits are going to continue. Again, like MAPIA is not new, it was passed way back in 2008, and I think we had the final regulations in 2014. But because we got this new documentation requirement last year, enforcement is ramping up. So I think another thing that we know is going to happen in 2023 is more participant lawsuits. I actually think that the comparative analysis requirement is going to accelerate litigation because it's going to be easier to bring a case because a participant can request the comparative analysis and it's easier to make the case in that sense. Possible for 2023 guidance from the DOL, I hope. I think Beth says no, but I hope. I'm an optimist, so I'm going to hope. I'm not going to say that I want it as a Christmas present because I'd like to take a breather for the holidays, but it might be nice for some sort of spring present. Like a model passing comparative analysis would be really nice. Like what plans actually have to do to meet the requirement. Another possible would be new legislation. The DOL did ask for additional enforcement power. So that would include increasing penalties because right now they're kind of shoehorned under ERISA. So increasing penalties, and then also getting the authority to pursue parity issues against TPAs, third-party administrators, directly, because that way it could effectuate change across many plan designs rather than just one plan. So that would give the DOL kind of more teeth with the penalties and then more efficiency with the ability to go after TPAs. So along those lines, we had the Mental Health Matters Act that was passed in the House a couple of months ago. It does a few things. It expands access to mental health services for kids or young adults in schools with new funding. It includes those penalties from a PIA enforcement. And then a big part of it is that it actually makes it easier to sue for denied claims. So that, because of that part, I could see this bill facing some headwinds in the Senate. But, as Beth said at the head of the call, parity is generally a bipartisan issue. And this administration and the previous administration, they have kind of supported giving enforcement tools to the DOL. So it'll be interesting to see how that plays out. And then Congress could also pass some more general measures addressing the mental health crisis, like grants for treatment, improving access for treatment. We obviously have a nationwide shortage of mental health providers, that sort of thing. So we could get, something mental health treatment related, but not necessarily targeted at employer-sponsored group health plans. What we really want is clarity on measuring these NQTLs. Just some quick takeaways for employers heading into 2023. You got to have this comparative analysis done, and it's tricky. I mean, you can't fix parity problems alone. So fully insured employers reach out to your carriers for the copy of the comparative analysis. Those insurers, those carriers they're directly responsible. But then self-insured employers is going to take working with your TPA, take a look at your administrative service agreement, figure out where those MPIA responsibilities lie. Because for a self-insured employer, the plan itself is responsible, not necessarily the TPA that's designing the plan or administering the claims. I think another good place to start is just look at your plan. Are there exclusions in there for something like ABA therapy or another autism treatment or wilderness therapy? And if you see it in there, talk to your TPA. Like, is this justified? Why is this in here? What was the thinking behind the design? And lastly, I would say really pay attention to participant complaints, because they could reveal some hidden MPIA issues. Like the DOL, if they're getting a complaint from a participant, I would say they're more likely to investigate that plan than choose some random plan, out of nowhere. And if you have a complaint, there's probably a denied claim behind that. So that could lead to a participant lawsuit as well. So really pay attention to those things and kind of investigate it. But that's a whirlwind discussion of parity this year and then looking into next year.
Yeah, it's super important. And I know we got a couple of questions, but I will say MPIA, as someone who worked at the DOL and has friends that are still there, they are really harping on this. They're teaching all of their investigators how to spot issues here. This is really an agency-wide push to kind of enforce that. So this is something where if you haven't done anything yet, then you definitely want to talk to your service providers about helping you at least review your plan, as Sarah mentioned. Thank you, Sarah, for that conversation on mental health parity.
My pleasure.
So now I am going to pass it over to Yoko, who is going to talk about state law trends. And I will say that like years ago, we didn't even really care about state stuff because ERISA is federal, but we're starting to see a whole lot of state action. So Yoko, what do you want to tell the people about state law?
Yes, thank you, Beth. So just to switch the gear from the federal interesting big topics, I want to go over some states level. I know a lot to go over, but I want to narrow it down to the key state updates that what employers need to know now and need to prepare before the 1/1 hits. And the topics will include states' paid family medical leave program updates and states' employer reporting, as you may recall, which is due in a couple months. And if time permits, commuter transit benefit requirement trends that we started to see at the state level as well as the city. So to start off with the state's paid family medical leave requirements. So before we dive into the specific to-do list for employers, I just want to step back. I'm seeing a lot of frequently confused areas that I want to clarify, untangle before to step back. So unlike many COBRA or other states' requirements like health mandates, state's PFML program requires to both fully insured and self-insured. In majority, except for Delaware and a few minor state, I shouldn't say minor, but like a few voluntary states, if you have even one employee working in that state, could be working from home, you are subject to that state PFML requirement. And another confusion is we get a lot of questions about, we provide STD or more generous benefits for, say, parental leave, or could be, caregiving leave, or could be disability. Are they like automatically be in compliance? And I just want to clarify that, unfortunately, that's not the case. One thing is that STD only covers for your employee's disability. That's generally the case. And it does not cover the family care, or bonding leave portion, which is the usually called paid family leave portion. And another thing is each state is very unique, unfortunately. So it varies by each state, and all states require, even if you choose that, not the state program, but the private plan, they have to get approval. And as of now, because each state's PFML is so different, I mean, the base is very similar, but some like family member definition and the length maximum benefit of those, like each requirement, each benefit limits are different among all the states. Therefore, each state requires private plan to get approval. And as of now, there's no like standardized plan, unfortunately, like medical portion, medical leave, and then PFL combined can be in compliance with all states, unfortunately. So what employers need to do is look at the list of employees, maybe like look at which states that you pay unemployment insurance with, and to see which state's PFML that you have to pay attention to and be in compliance with. And even if you choose private plans, most of the states still require like distribute notices of poster. If you go with the states, or some states only give option for state option, and then you have to register with the state ahead of time and then remit the contribution, usually quarterly basis. So a lot to think about. Especially with the COVID, a lot of your employees may be relocated to different states. It's hard to keep track of like each of them. So we are here, and we have a lot of good resources. If you feel like a little overwhelmed, we're here to support you. And just to focus on the more immediate to-do list, because it's a lot to cover. And on that slide, you can take a look at what happened this year. But for the interest of time, I want to just zero in on what you need to know now, the 411. So the immediate urgent to-do list is if you have any employees working in Oregon, Colorado, those are the new states that are rolling out with their own PFML soon. And if you have any employees there, you have to start withholding employee portion contribution starting from 1/1/2023. So again, even if you have one employee working from home in either of those states, Colorado or Oregon, you have to work with payroll vendor. You may need to also internally work with your payroll division to coordinate that deduction. And before that, you need to also communicate with employees. And those states have the template that you can also provide too. You don't have to come up with your own wording. And second thing that you have to do for both states, also share the same requirement, is that they came up with the template model poster / notice. It's basically the same thing that you need to display in your workplace. Or if they're all remote, then you can just email them. So you have to do those two things by 1/1/2023. And just to give you an update, so for Colorado, so their employees will be able to apply for benefits starting from next year, not next year, 1/1/2024. In Oregon, it will start from September 1st, 2023. That's when employees can start applying for the leave. And lastly, I want to also another key important things to keep in your mind is that coordination with your own employers, leave policy. I know many employers have parental leave or sick and vacation times. So, and many of your employers are subject to the federal FMLA, could be states. So it's important to make sure you're keeping track of which leaves are run concurrently and which leaves are job protected, and you need to continue insurance and those nitty-gritty important things. So it's important to put in the writing as a comprehensive things. And again, it may be overwhelming, but we're here to support. We have the good resources. And so that's that. And then just a quick note for the trend wise is interestingly, another 2023 one is the New Hampshire. New Hampshire, I guess it's a good thing. So they basically, this is a very unique state one. They contracted out to a private carrier. So MetLife won that bid. So they are the one that actually all the risk and a claim administration go to MetLife. So it's voluntary, so it's optional, which is good. However, if you have employees 50 or more employees, even one employee in New Hampshire, if you have 50 employees company wide, then employees, if they decide to purchase individual PFML policy, then you have to withhold that employee individual policy premium through the payroll. So that even is not completely out for that. And then, as you may know, Vermont just passed contracted with the Hartford, another private carrier, doing the similar thing, but they are not rolling out immediately soon yet. And quickly go over other state reporting. So everything that I'm talking about is in the attached link. Just want to quickly remind you there's no much there aren't any key updates for the 1094, 1095C that you submit to the ACA to the IRS. Also needs to some states like California, New Jersey, DC require employers to remit. That's coming up. So I just want to give you a reminder for that. And you can take a look in the slide, and we also have a good publication to remind you on the dates and how to do it. And again, majority of states more impose on the self-insured, but some like Washington, DC, also fully insured employers need to do. And another this is new, Washington, DC parking cash out reporting, which is due January 15th, 2023. So this applies for employers with 20 or more employees in DC, work in DC. Even if you don't offer free parking or subsidized parking, this is a new reporting that they need to do. And it's featured in our recent compliance corner that you can take a look as well. They have the site and instruction ready to go. So I think, so I want to, another part that I wanted to talk about quickly, just lastly, is the commuter benefits transit. The new one is rolling out is the city of Philadelphia. This is new. It will take effect from December 31st, 2022. And it applies for employers with 50 or more paid employees who work on average 30 hours or more. So same definition as the employer mandate. And they need to make that pre-tax transit commuter benefits program available, quote unquote, to eligible employees. So regardless if they elect or not, some employees may be located in remote, but they just make it, let them know that it's available if they're interested. So that's coming up effective December 31st, later this month. So I'm gonna hand it back to Beth.
Thank you, Yoko. And honestly, a lot of you might be employers who now have people who live everywhere, and that issue comes up quite a bit. Now, it's technically only benefits adjacent, right? Which is why I gave kudos to Yoko for kind of knowing a lot of that stuff. But with some of that stuff, you're going to be working with your employment law counsel potentially, or whoever does your HR, administration, and management. We just like to provide that information because we know we often get questions about it. So just really quickly, I'm going to talk about the Secure Act, and that's on retirement. And I know that the vast majority of you come hear us speak about health and welfare, and you may not do retirement. But retirement, honestly, the biggest thing I'll talk about is the fact that we're expecting that there's going to be some Secure Act 2.0. So the Secure Act was actually the biggest retirement legislation that we've gotten probably since the Pension Protection Act in 2006. And it was signed into law in 2019. Okay, and it's already kind of taken place. Like most of the things are already in force. A lot of you who have plans are already working with your 401k advisors to potentially make changes to your plan based on the Secure Act. But pretty much as soon as it was passed, like there were already additional changes that everybody kind of wanted and agreed on. So we expect that there is going to be new legislation on this as quickly as potentially this year with the reconciliation bill. Okay. Earlier this year, we got a bill that came out of the House, the Securing a Strong Retirement Act. We also got a bill approved by the Senate Help Committee, and it's like the longest acronym I've ever read for a bill, but it's the Retirement Improvement and Savings Enhancement to Supplement Healthy Investments for the Nest Egg, which is the Rise and Shine Act. That is ridiculous. I hope that is not the name of it. And then also we got from the Senate Finance Committee the Enhancing American Retirement Now Act, which is the EARN Act. That's a little bit easier. But we guess that there will be some iteration of this coming out. Okay. And so interestingly, some of the things that you did from Secure Act 1.1 or 1.0 will already change with Secure Act 2.0. So for example, a lot of you who have done this long, we did that the required minimum distributions age for the longest was like 70 and a half. And then the Secure Act changed it to 72. And now they're looking at changing it to 75, right? So like that's already kind of a quick change, but that's just one thing to come out of the change to the Secure Act. All right, so I don't see Carol yet. So I'm gonna let Kelly go. And Kelly is gonna talk about some of the, she just got in, but I'm gonna let Kelly go so Carol can get her bearings. So Kelly, can you talk about just some of the outstanding health and welfare announcements that we have?
Yes, thank goodness you're not going to ask me to talk about transparency and
I
coverage.
was worried.
So we'll let Carol get a hold of that. But yeah, definitely just going to hit on a couple quick topics. Nothing is new to employers, but good to know. So the first one we're going to touch on is enforcement of the employer mandate. You may hear of these being called 226J letters. So these are letters that come from the IRS. So basically what the IRS is doing, this is all tied to the employer mandate. And when you, as employers, are submitting those forms 1095 to the IRS, so sometimes we'll call this ACA reporting. So this is sort of the check and balance to where, you submit those 1095s to the IRS, and then if there are issues, potentially 1, 2, 3 years down the road, you may be hearing from the IRS via 226J letters. So those are basically letters the IRS is sending out that is telling the employer, hey, there may be an issue with your offers of coverage. And so these letters are going to propose penalties under the employer mandate. And these are really important. You typically have 30 days to respond to them, although you may be able to request an extension. So these first started coming out in, I think, 2017. And then we've really just seen an uptick in these as the years have progressed. There's no specific time frame for when one may come, although we've been seeing ones from plan years 2020 recently. So we expect to continue to see 2020 plan years and 2021 coming forward. Really the big thing here, again, there's nothing new about it, but just if you do get one of these letters, make sure you read it and respond to it right away. Because again, you have 30 days and there can be very large penalties associated with these. So you want to make sure that, you're reviewing it to figure out if you actually do owe this penalty, or maybe there was an error with the way those forms were transmitted to the IRS, several years ago. So it's really important. The big thing here is that 2021 was the last year that we had good faith reporting. So that's where the IRS was being a little more lenient with these forms. Oftentimes we'll see employers, even though they offered coverage to 95% of employees, full-time employees, a box didn't get checked. And they've been pretty lenient. Well, going forward after 2021, that good faith relief is gone. We may not see that leniency. So it's really important that as you're working on these, forms coming up in the next few months, that you are making sure that they are as accurate as possible. The other thing there is that obviously, if you get a letter, you have to be able to provide documentation that you did offer someone coverage. So getting those waivers of coverage, or that someone is waiving medical coverage at open enrollment, is so important. That way you have that letter that says, I offered them coverage and here's where they denied. If you don't have that proof, it's a lot harder to be able to show that you did offer coverage and maybe you aren't actually subject to that penalty. So really just a reminder here, the letters are still coming. Make sure that if you get one, you are reading it and responding to it right away, because you don't want to accidentally neglect to respond to it and end up with a penalty. The next one I'll talk about, this one may be a little bit in flux, is telehealth and high deductible health plans. So this was something that, historically when we think about high deductible health plans, we think of qualified high deductible health plans, which allows someone to be on the high deductible plan and contribute to an HSA. So historically, telehealth had been treated as first dollar coverage. So meaning that it was considered significant health coverage, and therefore you could not contribute to an HSA if you had, let's say, free telehealth coverage. Okay. Now with COVID, Chase talked about some of that earlier, with the CARES Act back in 2020, they said that telehealth services qualified as what they call disregarded coverage, which basically meant the plan could offer either free or very low cost telehealth coverage without affecting someone's ability to still remain HSA eligible. This was obviously a popular provision. And so it came about in the CARES Act, and then the Consolidated Appropriations Act of 2022 created optional relief. So back in March of this year, plans could opt to continue to allow telehealth to be considered as disregarded coverage for the rest of this 2020 calendar year. So as we are approaching the end of 2022, obviously, that is set to expire. Okay, so that means that unless we receive something else, in these next couple weeks, some sort of regulations, it means that if individuals are, in 2023 receiving low cost or no cost telehealth coverage under the plan, that's going to then render them ineligible for an HSA. So obviously plans, barring any last minute regulation changes that are going to extend this relief, plans need to make sure that you have the appropriate controls in place so that telehealth is not going to render someone ineligible for an HSA. And then the last one real quick, it won't be in the slides, but just on Monday, we finally got the final regulations from the IRS regarding the ACA reporting. So again, that's that Form 1095. So historically, they've been due January 31st. We've always gotten a 30-day extension, but it's never been guaranteed. A year ago, they put out some proposed regulations to make that 30-day extension automatic. And then we finally, on Monday, got the final regulations that really just affirmed those proposed regulations. And so therefore, the 1095C, the form that goes to the employees, instead of being due on January 31st, will now be due on March 2nd each year going forward. Now, this doesn't impact the timeframes for actually submitting those forms to the IRS, either via paper or electronic filing, but it does give that additional 30 days now to distribute that to individuals covered under your plan or those who you offer coverage to. And that's all I've got. So back to you, Beth.
All right, Kelly, thank you for that hodgepodge of just things to remember going into the new year. I'm going to turn over to Carol, who has about 5 minutes to talk about like 85 different transparency requirements. If you have to go, I want to like give her time, and maybe we'll go a few minutes after the hour. So if you have to go at the hour, we understand. Happy holidays. But Carol, can you talk about transparency for us?
Sure, I'll talk fast, and happy holidays, everybody. We've accomplished a lot. I think this is a year where a lot took effect with respect to the No Surprises Act, the surprise billing prohibitions, as well as transparency. And we'll start out with the surprise billing prohibitions. They took effect for plan years beginning this year. And as we know, they provided great protections for participants. designed to prevent them from receiving these huge unexpected bills for out-of-network services. So the No Surprises Act protects out-of-network emergency services, really broadly defined, includes ancillary services, post-stabilization services, air ambulance services, and also certainly certain non-emergency services that are provided by out-of-network providers. When you go in network, you schedule maybe a surgery and your anesthetist is out of network. In these situations, the participants' financial liability is limited. They really are limited to the in-network cost sharing, and it's generally based, if there's no state law, on the lesser of the bill charge, or what's known as the qualifying payment amount, which is the contracted rate for that item or service in the region. And the amount is applied towards their deductible and out of pocket. So participants fared very well. I think one area that was not covered was ground ambulance services. So perhaps we'll see that in the future. There are some commissions on that. But I think employers, hopefully have posted their surprise billing notice that needs to be on a site of the plan, a public site, where participants normally access information. And they should also be looking to amend their plan documents and contracts to incorporate these provisions. Where we also saw some changes based on litigation was with respect to the corresponding independent dispute resolution process. Once that participant has resolved, has paid their portion, their cost sharing, the plan is really left to resolve the payment with the out-of-network provider. And here, if there's no state law and they can't agree on the amount, we know that goes to the new federal independent dispute resolution, or IDR process. And under the original regulations that were issued, this process was designed so that the arbitrator, called the IDR entity, has to pick one of the parties' offers, either the plan or the provider. And they were really supposed to give the presumption that the contracted rate in the region was the correct amount. And the idea was that the provider and plan would likely make their offers close to that amount, and that would keep the plan cost down. Providers filed lawsuit, the healthcare providers, physicians, and in a Texas suit in February, they really won, and it forced the regulations to be changed. So right as of now, in this process, this IDR entity really needs to look at a host of factors, not just the contracted rate or give that priority, but other factors that could potentially increase the cost to the plan, such as the skill and level of training of the provider, the difficulty of providing a service to a particular patient. So, the bottom line here is that there are other lawsuits pending. We could see some more changes here. I think it's an area where we don't know exactly what's going to happen, but plans would want to monitor, particularly the litigation, and be aware of any changes with respect to plan costs. Just moving on to transparency and coverage rule. I think we all mastered the machine readable files, which we had to post starting in July. That was the plan level information, in-network items and services, historical out-of-network charges, on a public site, or where do we put the link? But I think everybody's got this process down. It is ongoing, and hopefully, the purpose of this disclosure was that tools would be developed that would utilize all this information that would help employers really to negotiate and get better pricing for their plans. So hopefully we'll see that happen. I think we are beginning to. The obligation's ongoing. One unknown is whether a prescription drug file will also be required. That was in the original regulations and just postponed due to the pharmacy benefit reporting that's now happening. The other thing I just want to remind people of is that the other part of the transparency and coverage rule, the internet self-service tool, is taking effect in part. It's a phased in effective date, but for plan years beginning in 2023. This is a self-service tool where online or by written request, a participant can request an advanced explanation of benefits, for a particular item or service. so they could know in advance the amount they'd have to pay. It would have real-time deductibles, out-of-pocket maximums. The initial phase-in is 500 items and services for 2023, all in 2024. Reach out to your service providers just to find out the status of this. I know some TPAs and insurers already have a similar tool in place, but you do just want to follow up on that. And then finally, just quickly, prescription drug reporting. This has been a difficult challenge because it's technical in some respects. This is a requirement that data for 2020 and 2021 on not just prescription drugs, but really also healthcare costs be reported to CMS by December 27th. We've heard they'll accept files through January 31st and hope that's going to be a good faith deadline without penalties before that date, but we're waiting to hear on that. Specific file requirements, insurers, TPAs, PBMs, hopefully they're doing most of the heavy lifting. We know in some cases employers are having to get involved in the filing. But again, we're looking for good faith relief. I think this first year will be the most difficult as all the kinks get worked out. But again, the purpose of this reporting is that the government will compile data in a biannual report that indicates the effect of prescription drugs on healthcare pricing and premiums, the effect of rebates. Hopefully this will be helpful as well to employers, and we expect that first report to be in June of 2023. So a lot has happened, and I'm sorry if I went over for a few minutes, but I think employers in general have done a great job with compliance with all these requirements.
I think, Carol, we're all just glad that you made it on the call, because Carol really is the preeminent member of our team as it pertains to transparency. She has learned it, and that has kind of meant that all of the rest of us did not have to learn it as well. So we're glad you made it. That's kind of what was going on this year, what's going on next year. Thank you, everybody, for staying with us. As always, it's a joy to do these, and just ending out the year, we're so grateful for all of you all. I'm going to turn it over to Amber, but happy holidays from our team. Wave, say bye, guys. Amber?
Great, thank you. Thank you to all of our speakers for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recordings in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you'll receive an email with a link to the full recording. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps make your education program as current and relevant as possible. That concludes our webinar for today. Thank you, everyone, for joining us, and have a great day.